Hello, welcome to Sullivan & Cromwell's podcast series, Sullivan & Cromwell Critical Insights. My name is John Hardiman, and I'm a partner in our litigation group. Today I'm going to discuss a recent decision from the Delaware Chancery Court concerning the fiduciary duties of controlling shareholders. The case is Clement versus Apollo Global Management, and it was decided by Vice Chancellor Travis Laster, who has been on the bench for about 15 years now and issued a lot of important decisions in Delaware Chancery Court, in particular in the controlling shareholder area. The case involved a company called Redbox, which should bring a little nostalgia to mind for some of you who used to rent DVDs from kiosks at McDonald's. That was Redbox. They were bought in 2022 by a company called Chicken Soup for the Soul. I don't make this up. And that deal spurred the lawsuit that resulted in the Clement decision. 75% of Redbox was owned by Apollo as a controlling shareholder, and the minority owned 25%. Minority shareholders, as they frequently do in a merger, brought a lawsuit claiming that the merger was unfair. The focus of the claim was something that's called in Delaware law unique benefits. The allegation being that the controlling shareholder got things that the other shareholders didn't get, and because it got those things, the deal went through even though it wasn't fair. That's the crux of the argument. I'll give you a little bit of background about the case, and then we'll talk about the decision. I suppose we would start with some really deep background, which is controlling shareholders and why they have fiduciary duties and when they have fiduciary duties. The why is controlling shareholders have the ability, due to their control, to force some transactions on the minority. When do they have them? Generally speaking, when they exercise control. For instance, if the management of a company decides a sale of assets is just the most wonderful thing in the world and urges its shareholders to go along with it, and all the minority shareholders want to do it, but the controlling shareholder votes against it, exercises its vote, that's not a fiduciary duty issue. Sure, controlling shareholders, just like all other shareholders, have the right to vote their shares any way they want. But if a controlling shareholder wants to buy the company or buy all the assets, so it stands on both sides of the transaction, then it's exercising its control to the detriment of the minority shareholders, potentially, and has a fiduciary duty. Those are examples. You'll see that the circumstances where the controller has a fiduciary duty can be in a larger array of type of transactions, which we'll discuss in a little bit. And also, at the very end, let's talk a little bit about where Delaware law is going with respect to controlling shareholder duties generally. Again, let's go to the case. Remember the kiosks. It's probably no surprise to you that with streaming and all the other ways you can watch movies these days, the DVD kiosk business is not going as well as it used to be, and nothing good happened to it as a result of the COVID pandemic. Apollo acquired Redbox in 2016 and had acquired 100% of it. It was run as a private company for 5 years when the controlling shareholder took it public through a de-SPAC transaction. As a result, the controlling shareholder had 75% of the shares and the public had 25%. Performance continued to go downhill because, well, what are you going to do? People started streaming more and more. And as a result, the company started to see if there was somebody who wanted to, if not buy it, at least help refinance its debt, which was becoming a big problem. They finally decided that the only thing they could do was sell the company. Outside financing was demanding it. Of course, the controlling shareholder had to get on board, and the controller agreed, but asked for two things. One, a mutual release for all legal claims that could be brought against it from the time it controlled the company. I believe the concern was that the new purchaser of Redbox could theoretically bring claims against the controller for mismanagement, waste, the type of things you bring against somebody who has been managing a business. I wasn't there at the time, but my guess is this came up because lawyers were involved. Let's face it, we lawyers always ask for a release. It's unclear from the record how controversial it was, but it was requested. The second thing that was requested by the controller is that it had given a $25 million loan to the company, the Redbox, which was up to about $28 million because of interest. And the controller asked that in the merger, either that loan be maintained or converted into equity of Chicken Soup, with the board of directors of Redbox to decide which it wanted to do. The board chose the latter, and as a result, the $28 million of the loan was converted into $28 million Redbox stock, and then in the merger, that stock was exchanged at the same rate as all the other shareholders for Chicken Soup stock. The net of all those transactions was that the $28 million loan became $2.8 million in Chicken Soup equity. The board of Redbox also agreed to the release, but not before it had a law firm consider what claims might exist against the controller. The conclusion of the board after getting the report was that they didn't really have any meritorious claims against the controller. And in any event, whatever they did have was eclipsed by the benefits of the merger. Once the merger with Chicken Soup was announced, it was not received that well by the market. The court referred to it as a dramatic take under. The stock was trading at $5.60 a share, but the merger consideration was 69 cents a share, plus, however, assuming all the debt of the company. The transaction was approved by a majority of shareholders, but not a majority of the minority of the shareholders. There is a decision in Delaware called MFW, which is important in this respect. Whenever there was a situation where a controlling shareholder was exercising control and therefore was considered to have fiduciary duties, the board's decisions were not judged by the business judgment rule on the theory that the board could not possibly act independently when it was dealing with its controlling shareholder. And therefore, entire fairness was the standard, which was a pretty tough one for any shareholder to meet, and usually was the death knell for a controlling shareholder in any litigation. About 10 years ago, former Chancellor J of Delaware re-examined controlling shareholder law, and it decided that things had gotten a little too out of balance because the entire fairness standard was forcing controlling shareholders to settle just about every litigation because it was so hard to meet. And so established something called the MFW, because the case was MFW, safe harbor, stating that if the transaction is negotiated by a committee of independent directors and is approved by a majority of the minority shareholders, then the transaction goes back to getting business judgment review. But here, those two things weren't done. There was no majority of the minority vote, although there was a special committee. And therefore, the question was the controller acting with control? Were its fiduciary duties implicated? Because if they were, then entire fairness would apply. The complaint, of course, focused on the release and the conversion of the loan into equity and argued that those two things were unique benefits. Now, again, a little bit of the law as background. The Delaware courts have found certain situations where a controller's duties are implicated and therefore perhaps entire fairness. The obvious one, as I mentioned before, is if the controller is buying out the minority. There, the controller stands on both sides of the transaction because the controller has the votes to affect the transaction it is initiating. And that's an obvious situation where entire fairness is implicated unless the MFW standards are met. The other situations where entire fairness can be implicated are a little hazier. One is if the controlling shareholder is getting more consideration than the other shareholders, which sometimes is obvious if they were getting $20 a share and everybody else was getting $15, but sometimes less obvious because the controlling shareholder may be getting other forms of consideration. But if a court finds that the shareholder did get different consideration, then entire fairness applies. Here we had the third type of case where entire fairness can be applied, and that was whether or not the shareholder got unique benefits. The theory being that if the controlling shareholder is getting things it really wants that nobody else is getting, the controlling shareholder will force the board to do the merger. And that's a little tricky situation because due to the fact of control, It's the very rare merger where there's a controlling shareholder where there don't have to be some things worked out with the controlling shareholder that aren't worked out with other shareholders. Could be contracts, there could be logistical things that the controlling shareholder is applying. And so not every unique benefit necessarily implicates entire fairness. It has to be a material unique benefit, which makes sense. And so the first question, unique benefit cases, do you have a material unique benefit? If you don't, business judgment rule, because the controlling shareholder is not acquiring the company and the controlling shareholder is getting the same consideration as everybody else. But if you do find there's unique benefits, or if the court finds that, then entire fairness applies, which is a tough one to beat. So with that background, the court then took on the two unique benefits alleged in this case. With respect to the discount, the court looked at that and said, when you take a $28 million loan and it becomes $2.8 million in equity, that's not a unique benefit. That's a unique detriment, is the way the court put it. And so therefore found that the loan was not a material unique benefit that implicated entire fairness. The release, a little more complicated. There is somewhat of a history with respect to derivative claims and mergers and acquisitions. One of the rules with respect to a derivative claim is that you need to be a shareholder at the time of the alleged injury and at the time you're bringing the lawsuit. If a merger intervenes between the time of the injury and the time of the lawsuit, you can't bring a derivative claim, because in a merger, you're usually cashed out or you get the stock of another company, and therefore you're no longer a shareholder. So is there any kind of cause of action for a shareholder who says, I think this merger either didn't take sufficient consideration when determining the price of claims that might be lost as a result of the merger, or sometimes even shareholders would allege that the merger was completed for the purpose of getting rid of the litigation. The Delaware Supreme Court, in the Parnes decision, Parnes versus Bally Entertainment, said that in that first situation, a shareholder could bring a direct claim alleging the price he received wasn't fair because the board hadn't sufficiently considered whether or not claims existed against the controlling shareholder. Vice Chancellor Laster, the judge in red box, had explored the Parnes decision and its implications quite thoroughly in a decision called Primedia, in which he explored when could a shareholder bring a claim that was found to exist under Parnes, but what were the more or less the boundaries to that sort of claim. What Vice Chancellor Laster did in Primedia is sort of examine the issue through the prism of standing. He said that a shareholder doesn't have standing to bring a Parnes-type claim unless he shows three things. First and foremost, that the alleged claims that were lost as part of the merger were material, that they would have survived a motion to dismiss, because how could anything be a unique benefit if the claims that were lost really didn't have much merit to them? Second, were they material in relation to the merger? For instance, maybe the claims would have survived a motion to dismiss, but maybe they were worth $10, in which case nobody would really do a merger because of them. And finally, are they the type of claims that were unlikely to be pursued by an acquiring entity? Because if they were going to be pursued by the acquirer, the shareholders wouldn't have lost anything as a result of the merger. Vice Chancellor Laster applied the Primedia test in the red box case to the release and determined that the third standard was easy. Obviously, the claims wouldn't be brought by the acquirer because of the release. But what he focused on, more importantly, was were there allegations in the complaint that the claims had any merit? And the plaintiff's complaint was peculiar in this regard, because while it said over and over again that there were claims, when it got to specifying them, all it did was list the claims that were reviewed by outside counsel to the controlling shareholder, and then cite the portion of the minutes of the board which said the board had concluded that the claims weren't worth bringing in light of the importance of the merger. But the complaint skipped the section of the minutes which said, in addition, the claims didn't seem to have any merit. Now, this is something of an aside. Some of you may be saying to yourselves, well, how did the plaintiffs know what the minutes even said? Well, that's because in Delaware, there is something called Section 220, which permits a shareholder who is considering a derivative lawsuit to get documents for the company. Of course, the quid pro quo for that is while it allows the shareholder to write a better and more detailed complaint, it means that the defendant generally can point out when there are documents the plaintiff got in the 220 demand that it's either ignoring or not citing that are relevant. And so we were able to point out, as counsel to the defense, that the plaintiffs were skipping the part of the minutes which said the claims that had no merit. And since the plaintiffs had declined to say anything about the claims other than to say they had been reviewed by outside counsel, in effect, the only allegations they had in their complaint about the merits of those claims were that they had none, because they had cited the minutes but left out the important part. It's probably important to note that in their motion to dismiss brief, the controlling shareholder did brief the merits of these claims. Yet plaintiffs in their response brief declined to take on that part of the motion to dismiss, did nothing to try and explain why the claims had merit. And therefore, with that record in front of them, Vice Chancellor Lasser decided he didn't have much choice but to grant the motion to dismiss. And so the court, after oral argument, read its decision for the bench and granted the motion to dismiss. And if you look through the cases from the Delaware Chancery Court over the last couple of years, you see it's the rare case brought against a controlling shareholder that's been thrown out at the motion to dismiss stage. So it was a happy development for the defendants. The court did take the opportunity of the ruling to talk about two issues that if you needed some clarification. The first is whether the unique benefit received by the controller has to be at the expense of the minority, or another way you'll see it said in a lot of cases, does there have to be consideration diverted from the minority to the majority to bring a unique benefit case? The court stated that being a court of equity, the court wasn't necessarily in the right case, and we don't know what that right case will be, but in the right case constrained by whether or not consideration has been diverted from the minority to the majority, meaning the minority, would have gotten $10 a share, but because the majority wanted these unique benefits, they got 9. The court said that the question turns on whether we approach fiduciary duty using the concept of compensatory damages, which focuses on the plaintiff's loss, the diversion, or principles of disgorgement, which focuses on the defendant's gain. The court held a unique benefit can arise where the fiduciary takes a benefit even if it's not at the expense of the minority shareholders. So be on alert that there could be situations where the controlling shareholder gets something in the merger that doesn't affect one way or another the price that the buyer was going to offer the shareholders, yet the plaintiffs may have a viable claim to get that thing back from the controlling shareholder. I guess we're talking about a situation where the record would show that the buyer was going to pay $10 a share no matter what, and that this whatever was given to the controlling shareholder wasn't going to affect that. The question is, can you get that back? And the court says in that circumstance you could. It'll be interesting to see what sort of claims are brought in the future based on this tenet. The second thing the court clarified was there had developed in the law a little something of a divergence between how Vice Chancellor Lasser had looked at the issue of whether claims that were lost could be unique benefits, and also the way that another Vice Chancellor, Glasscock, had looked at things. As I said before, Vice Chancellor Lasser looked at through the prism of standing, where Glasscock has not. And the court found at the end of the day, it didn't really make that big a difference, because both Vice Chancellor and Glasscock in their decisions had both held that however you approached the situation, for the claim to be a unique benefit, it needed to be viable to survive a motion to dismiss and be material. So that's the red box ruling. I think I said at the beginning that controlling shareholders can do whatever they want to do if they're acting as a shareholder. They can vote their stock however they want to vote it. But I think an area to watch is whether or not anything is added over time to what currently are the types of things that can cause something to become a unique benefit. Pardon me, cause something to go to entire fairness. For instance, right now we know a merger would, or we know disparate consideration would, we know unique benefit. Would other things also qualify something for entire fairness? In the TripAdvisor case, decided last year, what had happened was that the shareholder vote had resulted in the company changing its state of incorporation from Delaware to Nevada. And the court found that decision created unique benefits to the controlling shareholder because controlling shareholder law in Delaware, according to the court, was tougher than controlling shareholder law in Nevada. That was taking the unique benefit doctrine to a place it hadn't been before. And so it'll be interesting where things go. One thing that has always been of interest to me, and this is completely different than everything else I've been talking to you about on this podcast, and it'll be the case for another podcast if there's ever a decision that gets at this, but I've always been curious about whether or not a corporation can do anything to dilute a controlling shareholder's control if the controlling shareholder started to do things that were clearly bad for the company. It's been tried a couple of times. I was involved in a case in Vermont, of all places, that tried it where it didn't work. I know that in some of the fights between CBS and the Redstones, it was alleged but never really got anywhere. And if my recollection serves, there is a footnote in an opinion somewhere from a long time ago, which is sort of mused on the point. And I don't know if I just remember it this way or it said it this way, but your extreme situation would be, what if Adolf Hitler bought control of a company? Could you not do something as a board of directors to dilute who's control over the company? You would think so. And so that'll be all I got to say for you today. That's a recap of the Red Box case, a little learning on controlling shareholders, and a little musing about things that could happen in the future. Thanks for joining us today for S&C Critical Insights. Hope to talk to you again.